In the dynamic landscape of data protection, European Union legislation sets a high standard for privacy and security. This is particularly relevant in the areas of employment relationships and surveillance activities, where both individual rights and business interests intertwine. Let's explore how organizations can navigate these intricate legal requirements to ensure compliance and foster trust. Employment relationships, a complex terrain. The employment relationship is a multifaceted realm where personal data processing plays a crucial role. From the moment an individual applies for a job, through their tenure, and even after departure, companies handle a wealth of sensitive information. This processing must align with GDPR's fundamental principles: lawfulness, fairness, and transparency. Lawful processing and employee data. GDPR delineates several lawful grounds for processing employee data. Consent is a cornerstone, requiring a clear affirmative act from the employee. However, in practice, this is often supplanted by legitimate interests or contractual necessity. Legitimate interests. This applies when processing benefits the business in a balanced manner against employee rights. For instance, maintaining records of employee performance or disciplinary actions might be justified, provided employees are informed and safeguards are in place. Contractual necessity. Many processing activities, such as payroll management or benefits administration, fall under this category. Here, the processing is essential to fulfill contractual obligations between employer and employee. Data retention and personnel records. The storage of personnel records is another key consideration. The GDPR mandates data minimization and storage limitation, requiring that companies only retain necessary data for as long as needed. Regular audits are essential to ensure compliance, deleting or anonymizing outdated information. Additionally, companies must implement technical and organizational measures to secure personnel data, including encryption, access controls, and monitoring mechanisms. Workplace monitoring and data loss prevention. Workplace monitoring has become commonplace, from email checks to device tracking and CCTV surveillance. While these measures can enhance security and prevent data loss, they also raise privacy concerns. Transparency is paramount. Employees must be informed of monitoring activities and their scope. Furthermore, consent might be necessary, particularly for surveillance that exceeds legitimate interests. EU Works Councils and whistleblowing systems. Works Councils play a pivotal role in employee data protection, providing a platform for consultation on processing activities. This involvement helps ensure compliance, balancing employer needs with employee privacy rights. Additionally, whistleblowing systems require careful handling, particularly for sensitive information. GDPR compliance demands secure storage, lawful processing, and, where applicable, anonymous reporting mechanisms. BYOD programs and data protection. Bring your own device, BYOD, programs blur the line between personal and corporate data. To protect both, companies must implement comprehensive policies, covering secure storage, access controls, and employee privacy rights. Monitoring must be transparent, and any processing activities beyond legitimate interests might necessitate consent. Surveillance activities, a delicate balance. Surveillance is another domain where data protection laws apply with intensity. From public authorities monitoring communications to companies implementing CCTV, balancing privacy rights with legitimate interests is key. Surveillance by public authorities. Public authorities can process personal data lawfully, but must implement safeguards to protect data subjects. Oversight mechanisms ensure this balance, preventing abuse and protecting individual rights. These mechanisms, coupled with transparency, are crucial to maintaining public trust. Interception of communications. The GDPR and e-Privacy Directive govern communication interception, demanding transparency and consent. Individuals must be informed when their communications are intercepted, and the scope of monitoring must be clear. This extends to digital surveillance, balancing necessary tracking with privacy protections. CCTV and video surveillance. Video surveillance, governed by EDPB Guidelines 3/2019, necessitates lawful processing, balancing legitimate interests with privacy concerns. Footage must be protected against unauthorized access through encryption and other security measures, with retention policies ensuring storage limitation. Geolocation and biometrics. Geolocation tracking and biometric data processing are sensitive areas under GDPR. Geolocation requires transparency, with individuals informed of tracking activities. Biometrics, classified as special data categories, demand explicit consent for processing. Secure storage and limited access further safeguard against unauthorized use. Conclusion. European data protection laws present a comprehensive framework for handling personal data in employment and surveillance contexts. Compliance hinges on balancing lawful processing, transparency, and security measures, ensuring individuals' rights are respected. Organizations must integrate these principles into their operations, regularly reviewing and updating their practices to stay aligned with legal developments. In conclusion, navigating European data protection law requires vigilance and adaptability, particularly in the complex realms of employment and surveillance. By aligning with GDPR principles and implementing robust policies, organizations can foster trust and compliance, securing both their operations and individuals' rights. For continued guidance, refer to resources from the International Association of Privacy Professionals and relevant EU guidelines.